This is John Olegas, and this session is the second session about my experiences with the Marin District Attorney's Office. The first session talked about rights violations under Title 18, Section 241 and 242. This one is going to be about the perjury that was carried out by the District Attorney's Office in the proceedings where they kidnapped my children. The first document that I'm going to show is this document called a Hague Convention Access Order. It was issued pursuant to a petition that I filed. Right here in the introduction it says Ms. Jensen and Mr. Olegas are the parents of 8.5-year-old Caroline and Christine, 7. They both live in Kerry. I live in New Orleans. Mr. Olegas wants to have access to the girls in the United States. He has the assistance of the central authority, that is the New Zealand Central Authority, which is the New Zealand Ministry of Justice. This is a petition under the Hague Convention. It's not a petition to modify custody, because you cannot do that, because the court has no jurisdiction to modify or issue custody orders. Anyway, this order was issued on September 30th, 2002, pursuant to hearings. Now, I'm going to roll down to paragraph 22. Which addresses, and here it is. The terms rights of access are defined in the Guardianship Amendment Act, that is the New Zealand Act. The term rights of custody include rights to the care of the person of the child. Custody is defined as the right to possession. Mr. Olegas has an interim joint custody order giving him the right to the possession and care of the children for defined periods in New Zealand. Looked at broadly, Mr. Olegas' joint custody order must give him rights of access as defined in the Guardianship Amendment Act, and I therefore hold he has a right of access to the children in terms of Section 20 of that Act. So here's the judge declaring without question that I have an interim joint custody order, and my joint custody order gives me certain rights of access and certain rights of custody of the children. He declared that on September 30th, 2002. This is the order that Mr. Kusharian and Patricia Stafford claimed that gave Charlotte Jensen sole custody, even though the order itself says I have joint custody. Now, let's look at his claims. Here's where he filed an application to the court, where he told the court that the order from New Zealand that was registered in Santa Clara gave petitioner sole custody of the minor children. So the petitioner is Jensen. So how can that be other than perjury? He even says he's requesting the court that because I have fled the jurisdiction with the children, the Marin District Attorney's Office requested John Olegas not be served this petition prior to the removal of the children in Louisiana, and John Olegas' arrest for violating Penal Code Section 278.58. He's asking the court to let him violate Title 18, Section 241 and 242, and violate the clearly established law as outlined by the Ninth Circuit Court of Appeals in Ram versus Rubin. And he also is attaching the declaration of District Attorney Investigator Patricia Stafford, because she says the same thing, that Jensen had sole custody. All right. Now, here's another bit about whether Jensen had sole custody. This is the Ministry of Justice, who acted as the central authority in my petition under the Hague Convention, which we just referred to when we looked at paragraph 22. It says, in response to a letter from me on October 4th, 2004, says I could not locate any order on our file stating that sole custody or sole physical custody was granted to Ms. Jensen. So here we have the New Zealand Ministry of Justice declaring that Jensen didn't have sole custody or sole physical custody, contradicting Kusharian and Stafford because they perjured themselves. Here is Kusharian's petition, where he talks about how I violated a custody order that has been entered. There's never been an order entered in California courts. And he says that he can do what he's doing. And he says the facts surrounding the removal of the children in violation of a valid custody order. He's saying that the Hague Convention order is a valid custody order, even though the court hearing the Hague Convention proceeding cannot issue custody orders. He's saying that order, which I just read from in paragraph 22, is a custody order. He's saying that Jensen believes that I violated the custody order. It says, based on the above-mentioned investigation, the District Attorney's Office has concluded that John Olegas is in violation of the current custody order, that is the Hague Convention enforcement order, and has unlawfully removed the children from the state of California without the approval. So here he's saying I unlawfully took the children out of California. He also said earlier that my wife had sole custody, which that's been contradicted. And we'll get to Kusharian also perjured himself in a interrogatory on December 9, 2004, when he was asked, please indicate what information or orders you had that Jensen had sole custody of Caroline Christine. He talks about the registration of the New Zealand decision regarding custody. He's talking about the Hague Convention order, which said I had joint custody, and he's stating that it said that Jensen had sole custody. He's perjured himself. He knew he was lying. He did this to participate in the kidnapping and a framing of me. So that's the way it is in Marin District Court. Okay, so anyway, I'll just use that as my information that was provided, showing that Mr. Kusharian has, just as a matter of course, violated my rights and has perjured himself along with Patricia Stafford. Thank you for listening. There'll be more coming if you're interested. We'll be showing how I was extradited based on fraud, which has been admitted to by Mr. Kusharian, and he admitted that that this document that was filed on his behalf to the governor was fraudulent. Thank you for listening.